and celebrate this big event of 40 years. And in it, I also capture the preordained time, or the time of ordination. Who were there? Did it begin with us? In my paper, I say no. It began with the women
When the Bible wants to say something has come to an end, they'll say they waited for 40 years, for 40 days. 40 is an end of a season.
40, if you read the Old Testament, and it even overflows into the New Testament, is fullness.
You know, something continuous, not just because it's 40 years.
To me, is the victory of the church, that the church was able to embrace women.
And so we also celebrate the many men, the many leaders, our church fathers, who actually sat down and said it is time.
It's a moment of rejoicing over the joys and pains that I've gone through.
And I told God I would want to be a minister like this one.
The ones that cleared the thicket in the forest for us.
Because of the sacrifices they made, the battles they fought, you know, their great commitment.
In all humility, they are those who have been called home. They have paved the way for us.
To be with the Lord home, Jesus is still with you.
Our previous speaker talked about the women of the Bible who did not have names. But when we look at the Mary, mother of Jesus, when we look at Deborah, if they were not named, we would not know them. So I requested those 4 women to allow me mention their names, and some of them are in this house. Nancy Saure is there. Jennifer Mushemi is one of those. Anna Kenyajui is also in the house. Anna Kenyanjui, I saw her unless she has gone out. And myself. So if you get that book, if you get this paper, after this, you'll be able to read their stories because I cannot go through that story. So what do I write in that paper, because that is what I'm going to do here, is as we discover what Marion, what Mrs. Watson did and Mereka did, I wanted to see what other African women say about ordination or the emergency of ordination in Africa. And I quoted one African woman. I think we have heard so much of other women from those other places. And maybe having grown in Africa, standing in Africa, I have that very specific passion with what African women are saying. And today we are writing our story, the story of an African woman in a Christian church. So, Mercy Amba Onduyoye said, ordination of women in the churches in Africa was the very first issue that indicated an impossible disagreement between African women studying theology and women in the churches in Africa. If you like, and this is what the ones that were working in church and those seeking ordination, they told those that were seeking ordination, if you think you are going to seek ordination to become ministers so as to come and boss us around the way the men do, forget it. We will not support your quest. At the time of conference, at which this discussion was derived, of the 20 or so women, only one Presbyterian, a Ghanaian, was ordained of the 20. Another 2 were Anglican deacon from Uganda, and 1 a Presbyterian deaconess from Cameroon, and created a religious order for women. On the same breath, Mary, that name is very complex for me, Mary Toroirien, who is a Kenyan theologian, says, for a long time the church in Kenya has not known what to do with the women it has trained in theological colleges. Even those who are ordained often find themselves in their bookshops, in schools as chaplains, church department as Sunday school teachers. Today, many would want to wish away the women question in the church and the statements that are made by men in the church, such as things are better than they were for women. Those comments are often earned. The truth here is that there is a very long way to go before women are able to enjoy full and rightful praise in the participation of the church. As I read that, I want to recall the previous presentation by our Secretary General, by our first ordained lady, the Reverend Dr. Jane Nyambura Joroge, and also our Bishop, Right Reverend Emily Onyango. The concerns in the statement raised by the above quoted women indicate that even now there is an uphill task, because Jane Nyambura Joroge, the first woman to be ordained by the PCA in a groaning and languishing in labor pains, that is her writing, quoted this: my awareness of exclusion of women in the church continued to grow throughout my years at the university, where I was involved in a local church and an interdenominational student para-church organization. There were many debates and arguments, as well as some major incidents of personal pain and hurts, which revolved around the issues of leadership of women in the church. It was not surprising that many of us felt ourselves to be on the outside of the church. Working with an ecumenical body, together with the general exposure of the struggles of women all over the world, has facilitated this self-understanding of anger. Giving up the church at this time of my life is not an option, despite ongoing pain and anger. I distinguish here two varieties of pain and anger. Those I have experienced in my ministry, because I know how much others have suffered in the church, and those in my personal suffering as the one who has actually received the beating. The former are what are encounters when one enters into a solidarity with others, and the latter when one has to walk a similar path, knowing that I am not alone. Knowing that I'm not alone in this journey has helped me to accept the challenge of seeking for healing and being well. I have chosen to act rather than to continue venting my feeling and pain of anger. As a Christian woman, I have been forced to look to the scripture to ask where God is in all this ramble. She continues to recall. I remember that when I confronted the individual at the heart of personal crisis in the church, demanding acknowledgement, asking recognition of my presence and value, I was ignored, avoided, condemned, and blamed. I was threatened with being deposed from being a minister. So as I am thinking and I'm articulating in this paper, the journey traveled by African women, those voices speak so roundly in my heart. As I was going through the profiles of the over 50 women that managed to write their profiles, I was hearing those overtones of pain, overtones of cultural challenges, overtones of social challenges, overtones of institutional and structural injustices. Not to mention what I can tell about myself. So here I have the voices of the 5 clergy as they reflect on their journey of faith. These voices reflected here are true stories written by individual women. They are agreeable to the disclosure of their time. They have a reason to say Ebenezer. They have seen the reason to continue irrespective of the struggle. Of the 40-year celebration that reigns, Ebenezer, let us celebrate, rejoice, and witness for Christ. One has to stop and wonder, raising a number of questions. However, in the course, 1 minute, in the narrations and sharing of the experiences and encounters, it is evident that PCA ordained women clergy have a lot to celebrate and rejoice about, irrespective of the journey traveled by individual, and as they echo, as again it is echoed by Reverend Nyambura Joroge, who has to be celebrated and honored for clearing the bush. She went through art, anger, threat, as presented in her Beyond Suffering and Lament. That is another article she has written. Beyond Suffering and Lament, Theology of Hope of Humanity, Africa, and Christians. She goes on to argue that theologians, communities, that have made significant difference in ending suffering and restoring dignity in seemingly oppressed situations. In other words, our work speaks roundly, and so pregnant with that which needs to be known by the old Church of Christ, so that in that we will be able to welcome many more, irrespective of what is said. About you and me, about our church, our institutions. And other communities. Thank you very much.
Thank you very much, Dr. I've liked your topic. We are not alone. I can assure you, you are not alone. Even us men, we have no choice than to support you. I've liked the powerful small. While your husband has put on his
section drawn from Jewish canon, the Torah. These are the books that from the Old Testament and foundation to the New Testament. The Old Testament, therefore, is written in the Jewish context, following the Jewish culture. The Jewish culture was highly patriarchal and held the position of women below that of men. Women and children were subordinate to them. This influenced the choice of both secular and religious leaders who were men. This system flows into the New Testament as the apostles and Jesus Christ himself, together with the early followers of the Christianity, were drawn from a Jewish and Asian patriarchal system of leadership. Although there are few aspects of women actively being involved to the religious and secular leadership, the interpretation and understanding by the church through the ages has held a patriarchal view. Cultural influence against the ordination of women, as we see it in the history of the church. The church evolved chronologically from the time of the apostles, the early church, to the medieval church, the Middle Ages, the Reformation era, to the modern and postmodern church, or millennial church. The first three eras held a strong view against the ordination of women, from the diaconate to the episcopate positions of the scriptures, and then the society. Both the Eastern, Western, and Asian churches had their foundation built on patriarchal traditions of their society and interpretation of the scriptures. Women were hardly empowered to take the leadership roles in the church, and their contributions were hardly recognized or plainly assumed. Men were actively trained, prepared from childhood, to serve at different leadership capacities to the church. The last two eras has seen some significant efforts channeled toward the ordination of women and their leadership in the secular world. This has been brought about by the first woman getting empowered through secular and religious education. The Enlightenment has made women through the years protest their subordinated position in the church and the society through extensive writing and activist movements that propel the voice of women in the church and the society. This has seen many women coming out and mounting pressure to the church and the society, shifting the mindset of the people from the subordinating culture to the inclusive one. However, many churches across the world remain adamant with a few listening to the women's voices and ordaining them and even elevating them to the episcopate. Some women have restored to form their own ministries where they lead thousands in the capacity of bishops and pastors. And as we look at the culture influence against the ordination of women now in our African concept, we find culture in Africa is diverse, with different countries across the diverse continent boasting of their cultural peculiarity. But again, amidst the cultural diversity in Africa, patriarchy remains the common culture across the various African communities. Patriarchy defines the leadership system as the African society, and this system permeates to the church, enlightening itself with a biblical patriarchal system. In the African traditional region, women cannot bear a religious office, with very few communities having women as religious leaders. This same notion of born by those in church as leaders and congregants, ordained and lay people among men and women, as we would find Dr. Emily explaining that at times even the women are so patriarchal in their mind by themselves. The cultural aspect in the patriarchy, where the man is the head, the woman is a priest and the defender of the family, clan and society is married with the biblical of men leading and protecting. This in turn makes the great people deeply rooted in their tradition and interpreting Bible in text of those intimidation. The rigidity in many African communities have made women denied spaces of leadership in the church, being denied ordination, and even in their ordination, some face rejection. A good example, we were told by Dr. Emily, an example, she attended an event of the clergy, and she was introduced as not who she was at that particular time, and she had to leave. And so we find many women who get ordained in the ministry are viewed as they have been given a favor Others barely accept the next office in the church. Many churches are not ready to allow women into the ordained ministry, citing the problem of culturalization and scriptural interpretation. Others claim that they are following historical precedents, and this has left women to fight for position in different spheres within the church, to empower themselves further into the leadership structure of the church. And as I conclude, Paul in the Galatians chapter 3 and verse 28 states that there is neither a Jew nor a Greek, there is neither bond or free, there is neither a male or female, for we are all one in Christ Jesus. Nobody should base the concept of ordination to gender. This should be based from the deeper understanding of God's call for all, competence, character, and desire to serve. And we shall be able to join together in hands and say, Ebenezer, let the woman that the Lord has called to serve rejoice and witness in fulfillment of her purpose and mission in the vineyard of the Lord. Thank you, and God bless you.
Thank you, Laban. Let's clap for him properly. You know, I grew in a church where men were not to close eyes when a prayer was being said by a woman. Up to today, I've never known why we were told not to close our eyes. Maybe wasituibia, hatukujua hasa. Our next presentation also virtually.
Nimeonekana kwa TV.
Next presentation.
Wameleta picha yangu, lakini
Hello, Ruka.
This is frustrating. Well, I'm looking to the fields of how to bring on board women to serve, and for this reason, celebrating when PCA training 22. And there my question comes, what is this that the
When the Bible wants to say something has come to an end, they'll say they waited for 40 years, for 40 days. 40 is an end of a season.
40, if you read the Old Testament, and it even overflows into the New Testament, is fullness.
You know, something continuous, not just because it's 40 years.
To me, is the victory of the church, that the church was able to embrace women.
And so we also celebrate the many men, the many leaders, our church fathers, who actually sat down and said it is time.
It's a moment of rejoicing over the joys and pains that I've gone through.
And I told God I would want to be a minister like this one.
The ones that cleared the thicket in the forest for us.
Because of the...
who were lawfully at the tallying center was seriously injured. To date, nobody has been asked even to write a statement on what happened on that day. Today, no investigations whatsoever have been made by the agencies of state which should be doing this. And to date, this heinous and frontal attack on our democracy remains unresolved, and the perpetrators are marauding around the country, and some of them are in this courtroom. Chief Justice, judges of the Supreme Court, the events on that fateful day mirror what, in our respectful view, took place on January 6, 2021, when a rowdy gang of violent protesters laid siege on Capitol building in Washington, D.C., in the United States of America, following the spectacular defeat of Donald Trump as president of that country in the 2020 election. The chronology of events of that day, the day our country was shamed in the eyes and in the presence of diplomats from all over the world, local and international press. The events are detailed in the affidavit of Mr. Wafula Chebukati, a gallant son of Kenya. That affidavit is before this court and is dated 26th August 2022, particularly paragraphs 58 to 75. This has been corroborated, my lords, my ladies, by the affidavit of Professor Abdi Gulie and Boya Mulu, the affidavit of Boya Mulu, both of which are before this court, and the relevant parts are paragraphs 17 to 37 and paragraphs 9 to 10, respectively. We respectively submit that the aforesaid activities at the National Tallying Center on 15th of August 2022, regrettably perpetuated by emissaries, agents, supporters, and sympathizers of the first petitioner, who is now before this court seeking redress. Those events and those activities amount to nothing short of a flagrant attempt to overthrow the constitution of our country, to subvert the sovereign will of the people of Kenya, contrary to Article 1 of the Constitution. It It is our view that those events alone constitute nothing but an attempt to establish a government unconstitutionally, contrary to Article 3.2 of the Constitution. And in our humble and respectful view, Chief Justice, my lords, my ladies, the events of that day are basically an attempted but failed coup d'etat. Unfortunately, the jurisdiction of this court under Article 140 does not allow it to punish these egregious acts of treason, but these events must inform the context in which the main petition and its offshoots ought to be adjudged. Curiously, the mentioned public officers, who include civilian state officers, including a cabinet secretary, senior military officials, including the Vice Chief of Defense Forces, head of police, head of intelligence, the head of public service and chief of staff, which itself is an illegal position under our constitution. All those people have not denied that they met the IEBC in plenary. The only thing they have told this court is that they went there to try and fast-track the declaration of results and not to do what Mr. Chebukati has told this court on oath, which is they went to go and try to have the first petitioner declared as president of the republic, or otherwise force a runoff between him and my client. With tremendous respect, we ask this court to consider those acts as not only destructive to the independence of our institutions, but more particularly an affront on Article 249, 2A of the Constitution that describes the IBC and other such independent institutions in the following words, that they are independent, and I quote, and are not subject to direction or control of any person or authority. That includes, in our humble view, positive and negative interference, even if, for argument's sake, which is denied, those heads of very sensitive institutions walked into a plenary of the IBC to fast-track the declaration of results. Even that in itself is illegal and unconstitutional. What are the principles upon which the context we have laid should be adjudicated? Chief Justice, members of the Supreme Court, it is the submission of the first respondent that there are at least three immutable principles that run across most Commonwealth jurisdictions upon which this petition and its offshoots should be adjudged. One is the principle that no election shall be questioned or declared void because of errors, informalities, irregularities, or illegalities that have little or no bearing to the process and the result. This principle, Chief Justice, judges of the Supreme Court, this principle has endured for more than 150 years and was first initiated in the United Kingdom Ballot Act of 1872, Section 13. Two, that the burden of proof in election petitions lies on the person who seeks judicial invalidation of the election, not on the respondents. This principle has been cited in one of the authorities we have relied in and already highlighted by learned counsel's senior counsel Fred Ngatia, the case of John Mahama versus the Electoral Commission of the Republic of Ghana, 2021. Principle number 3, and this is specific to Kenya and the minor KI decision. The polling station is the true locus for the free exercise of the voter's will, and I'm shocked to see the petitioner and the latest pseudo petitioner, because when I listened to the Attorney General with due respect, I clearly thought that we are listening to another petition, especially on the issue of Article 138.3c, despite the assurances that he was not opposed to any petition, and I think he fell short of saying he's supporting the petitions. What are the specific principles in the interest of time? The first one, those are the 3 are the general principles. What are the specific principles? 1, C carried out verification, tallying, declaration of results in compliance with 138.3c and 138.10. These are the reasons. Number 1, the verification and tallying happened and was done by the chairperson, commissioners of IBC, and the staff at the National Tallying Center in the presence of the candidates of the agents of the presidential candidates. And this is in the affidavit of William Ruto, paragraphs in support or in opposition of the petition, paragraphs 18 to 20, and the affidavits of Veronica Nduati, paragraphs 7 to 14. Number 2, the IBC complied because an interpretation to the effect that Article 138.3c refers to the 7 commissioners, or a majority of them, is inaccurate and pedantic for this reason, that the Constitution and the Elections Act attributes to the Commission certain acts that are eventually done not by commissioners, but by both the permanent and temporary staff of the IBC at the polling station, at the constituency returning the constituency tallying center and county tallying center, and I dare say even at the national tallying center. And that explains why, for example, the Constitution in Article 86.5 and 86B and 86C talks about the commission, but the work eventually is done by returning officers and in the first instance by the presiding officers. C, B, and C of Article 86 of the Constitution, which is not speaking about the National Assembly election or any other election, but the presidential election. The actions of returning officers, presiding officers, are deemed to have been done by the Commission, and that explains our argument. Number 3, an interpretation to the effect that Article 138.3c refers to the 7 commissioners would lead to an absurdity in interpretation, because it is not humanly possible for the 7 men and women who are commissioners, however important they think they are, it is not humanly possible for them to tally results emanating from 46,229 polling stations across the country at the moment. Number 4, verification, tallying, and declaration was done because the right to franchise, Chief Justice, judges of the Supreme Court, this right in Article 38 of the Constitution cannot be subjected to the will, to the veto, or even to the ego of 7 men and 7 women. Even if, as they claim, they think they hold the constitutional veto to try and moderate or alter or balance the will of the people as expressed at the polling station and as received in original 39 A's. Number 5, verification, tallying, and declaration was done. Even, I dare say, Chief Justice, judges of the Supreme Court, even for the 27 constituency results that were not verbalized. They were not announced verbally, but they were declared because they were posted in the website after chaos broke out at the National Tallying Center. I want to invite the court to consider in interpreting whether what has been pleaded before this court in terms of what the commission did after that risk on life and limb happened. I want to plead and persuade this court to invoke, by way of analogy, 3 doctrines of law. The first one is the doctrine of frustration in the law of contract, where there are contractual obligations to be performed, but the contract is frustrated. Number 2, the doctrine of necessity in international law. And thirdly and finally, the doctrine of supervening impossibility, where there are legal obligations, but the party on whose those obligations accrue cannot perform them as a result of supervening impossibility. Chief Justice, my lords, my ladies, number 6, the IBC verified and tallied and declared all the results because none of the 46,229 from 34 A's have been impeached. Number 7, the IBC verified, tallied, and declared all the results because the tallying that happens at the National Tallying Center is basically clerical. And I think the commissioner should know none of them, including the chairman, has any role whatsoever that is significant other than just recording the clerical and arithmetical issues. And this is so, and this explains why, even when there are discrepancies between what was transmitted through electronic means and what comes as a physical form, the best that the chairperson, as the returning officer, can do is to note the errors in the error form, and only this court can actually interrogate and decide on the fate of those discrepancies. Number 8, verification, tallying, and declaration was done pursuant to 138.3C and 138.10 because an interpretation in the opposite direction would lead to a constitutional crisis where commissioners who think they have a role to veto and moderate the expression of the will of the people of Kenya in the vote can decide to form factions and have their own candidates, declare their own results, which they have verified in quote and tallied in quotes. Finally, Section 10, 11, and 11A of the Elections Act envisage the commission to include the secretariats and staff, and therefore verification was done according to the affidavit of William Ruto, the affidavit of Veronica Duarte. The tallying was done in the presence of agents at the National Tallying Center. With tremendous respect, I would like to conclude by submitting that this court should find that a petitioner whose agents and supporters are engaged in a kind of behavior that is now of public notoriety, and I invite the court, over and above what is pleaded, to take judicial notice of of the events of that day. A petitioner whose supporters, sympathizers, and agents engaged in those kind of things should not be anywhere near the hallowed ground of a Supreme Court of the Republic of Kenya, trying to seek relief, among them a relief under Section 80A, that they be declared winners of an election that they didn't win. We submit that the mob that swelled our image, the image of our nation, including the conductors of the orchestra, are now before this court shouting loudest that we must release Barabbas. This court should stop Barabbas and his mob from benefiting from their own malfeasance. We pray that all the petitions, including the submissions by the Attorney General, particularly on this issue of Article 138, those petitions be struck out with costs. I respectfully and humbly submit. And now, with the permission of the Chief Justice and the court, I yield the microphone to Senior Counsel Kirago Kimani to address the court and submit on issue number 7 and number 8. I thank you.
May it please the court, I will not, my name is Kirago Kimani, I will not address you on issue number 7. I believe it's been adequately dealt with by the IEBC and its chairman. I will address you on only issue number 8, and I will try and avoid rehashing what the IEBC and its chairman addressed you, in my humble view, very effectively. This is simply looking at the test that has to be met by the petitioners in order to determine whether the election should be nullified. And you've settled this as far back as 2013 in Raila petition number 1, or it was petition number 5 actually, but it was the first election petition under the new constitutional dispensation, and repeated this in 2017. The long and short of it is that the question you must ask is whether it has been demonstrated that the election was conducted so badly that it was not substantially in accordance with the law relating to elections, in this case the Elections Act and Articles 81 and 86. The burden is squarely on the petitioners to demonstrate indeed this is the case. The word used by Section 83 is magnitude, of such magnitude, really. It is not enough to demonstrate there were irregularities. It is not enough to show that there was a breach of the law. But it has to go beyond that to show that it affected the outcome. Has that been done? I'm not going to take you through the multiple allegations of irregularities and breaches of the law. But I've tried to look at these petitions, the 7 surviving ones, and I think there are approximately 46 allegations of breaches of the law and irregularities. This is a classic case of throwing everything other than the kitchen sink at your opponent. There are a lot of overlaps, but by and large, everything that could be said has been said. And I'll come back to this. The kitchen sink did show up a little later. But I don't want to walk you through all of these allegations. Let's just look at a few of these. It's alleged that there has been an infiltration of the IEBC system. I'm not going to rehash what Mr. Mahatomane so well explained to you. But I think these petitions are an invitation to this court to lay down the law. It's one of your jobs. That it's not enough to show up here and throw things out there and say, we hope some of it will stick. No. People must be held to account. They must be told, show us where the evidence is. And indeed, this is what Rule 9 of the Supreme Court presidential election rules requires, that when a petitioner presents a petition, they will also furnish evidence. Has that been done in my humble submission? No. This evidence of infiltration, in the first instance, was put in various affidavits. John Mark Githongo, you've been told about how he recanted this. There were allegations in various other affidavits. And what happened then? There was a robust response from the referee, the IEBC, and the first respondent. And then what do we have? We have a second burst of alleged evidence in the nature of an affidavit by George Njoroge. And we are not even, we did want to start playing games by saying this evidence should have come at the start, as the rules require. So this case keeps being panel beaten as we move along. And it's not just petition number 5 where this happens. It has happened in another petition where you were addressed about 291 constituencies and not 290. I believe there was a question from a judge directed at this, because there's a short answer to that, but the question was not directed at me. But that wasn't even pleaded. So what we have is a situation where you keep being told new things as we move along. There's another allegation that the IEBC was so dysfunctional that you couldn't possibly have an election that complies with the dictates of Article 86. And we are told that this started even before. Now the question is, why wasn't a challenge made to the mandate or to this institution before the elections? An Article 140 petition is very narrow. It concerns the results and nothing more. This petition has been turned, or these petitions, by many of the petitions, has been converted into an attack on the on the chairman or the chairperson of the IEBC. It's not the function of the court to look at the conduct of the chairperson with a view to taking action. You are addressed in great detail as to why or how he has affected the last 2-3 elections. So what were we waiting for when Article 251 tells us what to do? The Leadership and the Integrity Act tells us what to do. Let me very quickly, without going into any more of these 46 alleged irregularities and breaches of the law, just try and illustrate just how bad these petitions are, or how lacking in substance they are. And I will, Mr. Mahat Somane, my land friend, Mr. Mahat Somane, has spoken to this, but I want to illustrate by showing you just a little bit about what was contained in the affidavit of Arnold Odinga, Ochieng Odinga. And if I could just, if it could be put up, I want us to look at what has been presented before this court. And it's quite easy to come to this court and say, listen, somewhere between the people expressing their will and the declaration of the results, there's been some tampering. Let's look at what they say. Paragraphs 81 to 91 of the affidavit of Arnold Ochieng Odinga says that there was willful, deliberate, and criminal tampering of the of certain results, and they've identified 41 forms. What I suspect they did not expect to happen is that the IEBC would respond to just about each and every one of these forms. Let's look at just one sample. And before we do that, what are we trying to achieve? We'll look at a Form 34A from the IEBC portal. We will look at a Form 34A delivered by IEBC to the court. We will look at an affidavit from a presiding officer, and we'll look at an affidavit from an Azimio agent, and we'll look at a Form 34A provided by a UDA agent. The affidavit of the IEBC presiding officer is not part of the slides, but we will be able to compare these documents. If we could skip this next slide so that we move quickly. Let's skip that slide, please. Now the question is where the petitioner's fraudulent 34, or allegedly fraudulent 34A came from, and I'll return to that at the end. Let's just look at Kibagare polling station. The next slide, please. If you look at the signatures, one of the signatures is an ODM agent, Mr. Eric Atuma. Now the petitioner in petition number 5 has filed many affidavits in response to the respondents, including the first respondent. They have not responded to this. They have not challenged this, but they put it out there as an illustration of what games were played either by the referee or in concert with the first respondent. So the first thing you note is the signatures of the two agents. The next thing I'd invite you to look at is what the votes were according to the IEBC portal. And Malanfem Mahat Somane invited you. The portal is up and running. Check this. What was the total of votes cast, or what was the, for the two candidates in Kibagare polling station, stream 2 of 7? Raila Amolo Odinga, 244. Mr. William Samoei Ruto, 114. Let's go to the next slide. If you look at the affidavit of the presiding officer, he's produced a similar Form 34A. It says it gives the same outcome. The next slide. The UDA agent, same 244 and 114. Then you have the next slide, the Azimio agent, again, 224, 114. The next slide is the affidavit of their own agent. He says, what is in Mr. Odinga's affidavit is not what I submitted to the party. They decide, we're not going to respond to that. But we expect the court somehow to determine that there were fraudulent Form 34As. Is this right? Let's go to the next slide. What is in Mr. Odinga's affidavit? Look at the last column. It says, for Raila Amolo Odinga, 244 votes. For Mr. William Samoei Ruto, 38. What happened to the other votes? Something is fundamentally wrong. And this is just one document. We have filed other affidavits which illustrate what happened here. Let's look at the next slide. The law requires the IEBC to deliver certain forms. I'd invite the court to look at the form for this particular location, this particular polling station, and see whether what has been set out in Mr. Odinga's affidavit is correct. Let's go to the last slide. What then are we telling you? The numbers between the IEBC portal, the IEBC presiding officer, the UDA agent, the Azimio agent, and the Form 34A from Bomas are all aligned. Question we must ask is, where did the form that is presented by Mr. Odinga come from? Arnold Odinga, so that we do not mix up names. I think this must be what the late Issa Juma of Super Wanyika had in mind when he penned the words, sisi twajua anafanya biashara, lakini biashara anajua mwenyewe. Only Mr. Odinga can tell us where this came from. And the other 40, they are not part of what was actually the product of the people expressing their will. So, in a nutshell, even without trying to demonstrate to you how the other irregularities and alleged infringements of the law have not affected the law, the petitioners fall far short of what is expected. But let me look at one or two things, because one of the things that has really featured a lot, and I'm going to try and avoid rehashing what has been said by the other lawyers, is that the commissioners have a significant role. That what 138(3)(c means is that the commissioners, the 7 men and women, have to be involved in the exercise that is to be undertaken. With respect, this submission is skewed by a failure to interpret the Constitution correctly. I think it's long been settled that the Constitution, the interpretation of the Constitution, looks both at the text and the context. And what has happened here is that the petitioners have decided we will stick with the text. And even that they stretch. They say the IEBC, the commission, means there's 7 of them. With respect, that's an invitation to the Supreme Court to, through the back door, overturn what Minor Kiai said, which is that you start at the lowest level and cascade things, but it is not the job of 7 men and women. Let's look at the 7 commissioners a little more, and in particular the 4 who it is said should lead to the conclusion that the election was not conducted in accordance with the Constitution. Board with every other commissioner, they spoke with one voice until about 3 p.m. on the 15th of August. Then they had their Damascus moment and made it to Serena. They changed their position. If you look at the affidavit of Samuel Gidai, look at the clips of the 4 commissioners announcing the results. But you were told here yesterday they were being given pieces of paper to read out numbers. Is this believable? But we were told by another speaker, another advocate, that these men and women were vetted by the National Assembly. They are therefore very serious citizens who correctly undertake a very important function, the running of elections. But they say they did not participate in this. In determining who to believe, look at the context. Look at the whole series of events from when the nomination took place, when the ballot papers were printed, including the supervision that they undertook, and determine whether these 4 commissioners are to be believed. Mr. Njenga, for I think the 7th respondent, argues they are here not to support either side, but to discharge their duty under the Constitution. But they did file a response. They started off by filing affidavits to set out the evidence. There's no property in a witness. They didn't stop there. On the 26th of August, they decided, we will appoint another lawyer on behalf of the IEBC who is in effect going to admit the alleged infringements. This is where you apply the duck test. If it looks like a duck, if it swims like a duck, if it quacks like a duck, it must be a duck. They are saying we are here to show you we are independent. Are they? With respect, their conduct demonstrates otherwise. In a word, it is my humble submission that the petitioners have not demonstrated there were any irregularities or illegalities. Forget the magnitude. They really haven't demonstrated any. I'd urge you to dismiss these petitions. Ordinarily in these sort of cases, and I'm not telling you what to do one way or the other, because of the nature of the matters, the parties are asked to bear their own costs. But again, what happens in 5 years if people can come in 8 petitions, 1 was struck out, and say whatever they wish to say without offering evidence? I think there was some advocate who said yesterday, we're going to have 200 petitions in 5 years. Why? Because nothing, there are no consequences. We can all come here and be on television, there are no consequences. So what are we asking of you? We are asking you to give us back our country. Determine that there were no infringements, that we had a proper election. We have been in election mode for so long. The only thing that creates wealth is actually working. And this is not work. With respect, the tens of thousands, men and women who preside over elections are teachers and farmers and artisans and you name it. We're being asked to make them come back to work in a few months, or in 60 days to be precise. There is no justification for that. The order that should commend itself to you is to dismiss these petitions because they fall far short of what is required. Those are my submissions. Mr. Kyoko Kilukumi will now address you on the 9th issue.
Your Ladyship, the Chief Justice, Deputy Chief Justice, Justices of the Supreme Court, my name is Kyoko Kilukumi, and I appear for the first respondent. Our team leader has asked me to deal with the issue raised by Mr. George Oraro, Senior Counsel, in regard to the affidavits filed by Joseph Kinyua and Kennedy Keara. This court did direct that this first respondent is at liberty to come and place the facts he has before this court, not through affidavits, but we've been given the permission to place the facts because time was running and the court directed we have that time. The first respondent wishes to place it on record that under Article 240 of the Kenya Constitution, there is established a National Security Council. And he is, by virtue of being the substantive deputy president, is entitled to sit in that council. He says, in the last 5 years, the council has not sat and discussed anything to do with elections. He further says that matters of election are vested in an independent body, and that independent body is the IEBC. That is the body that has the constitutional mandate to deal with elections. He further says, during that period of 5 years, the Council has not asked the National Security Advisory Committee to deal with IEBC on any matter relating to elections. And he takes the position that the visit by members of the National Security Advisory Committee to IEBC at the Tallying Center was an interference with the functions of IEBC. And it was calculated, given the membership who was sent there, it was designed and calculated to intimidate the chair of the IEBC and to seek to influence the outcome of the election. We ask the court to note that these affidavits were provoked by what Mr. Chebukati said in his affidavit sworn on the 26th of August, 2022. From paragraphs 55 to paragraph 75, he has given a subheading, and he calls it an attempt to subvert the will of the people. And we invite the court to consider those paragraphs and to see which party is telling you the truth. We wish to refer you specifically to paragraph 66 in that affidavit. And it is an important averment, an important deposition in that affidavit. He says, Mr. Chebukati, when he was at the National Tallying Center, members of the National Security Advisory Committee visited him, and he sat with them after 2 p.m. It is important to contextualize the time. We are talking of the 15th of August, Bomas of Kenya. There is a meeting, and this meeting is attended by all the commissioners. All the 7 commissioners are there. The fact of that meeting is not disputed, or the affidavits filed regarding that matter make critical admissions. The first admission is that indeed Joseph Kinyua telephoned Chebukati and told him, I'm sending my members to you. That's an admission. The second admission is that all the commissioners, and these are the affidavits from Mr. Joseph Kinyua and Mr. Kenneth Kiara, all the commissioners were present. It is past 2 p.m. It doesn't say how long this meeting took. The country had been put on notice. Elections results will be declared at 3 p.m. And once you look at the paragraph I've referred the court to, Mr. Chebukati says the message from this powerful committee was simple. Declare these elections in favor of the petitioner, the first petitioner, in petition number 5. If you are not able to do so, please massage the electoral data and force a runoff. And now that issue was discussed openly by the members of this powerful committee and all the commissioners in IEBC. The 4 commissioners made it very clear the suggestion from the Security Committee is reasonable and we should actually accommodate it. We should think of doing it. The 3 commissioners, and all of them have sworn affidavit attesting to that. The 3 commissioners said, nothing doing. We will declare these elections in accordance with the Constitution of Kenya, and we will declare the legitimate results. And so we ask the court, you do not have the advantage of witnesses being cross-examined, but you have the ability to look at all the accounts and see which account is more probable. The meeting starts past 2. Elections were to be declared at 3. At 4 p.m., the 4 commissioners are in the Serena Hotel. Our TV screens has been split. One side says 4 commissioners are disowning the results. The other screen is showing us chaos in Bomas, attack on the chair of IEBC, attack on the 2 other commissioners. Do you believe, will this court believe, that members of the National Security Advisory Committee was going to discuss matters of security when in less than 1 hour, 2 hours, the electoral commissioners are being assaulted, and this is being broadcast live. Assaulted, a cognizable offense. Police are in Bomas of Kenya. Nobody's arrested, and the people who are doing these attacks are well known. So we ask you to consider that fact in trying to see which account is likely to be true. The commissioners at Serena Hotel opened by saying, we've conducted a very good election. It's only gone bad towards the end. You will ask yourselves, does somebody disown results which he doesn't know? Do you believe these commissioners did not know what the outcome has been? We submit they knew the result, and that is why they were disowning it. We also ask the court to consider these 4 commissioners, apart from the press they did on 15th of September, they again did it on 16th, the following day, 16th of August. Was it a coincidence that again our TV screens were split into 2? You see the 4 commissioners, and you see the first petitioner, and they are speaking the language they are talking. The words they are using are strikingly similar. Is it a coincidence? These are matters we invite the court to consider in trying to ask itself, which account do we believe? I urge this court to believe the account given by the 3 commissioners. The will of the people was just about to be subverted, and the attempt was unsuccessful because the 3 commissioners stood by their oath of office and faithfully executed what was expected of them by the Constitution of Kenya. This split between the commission, the court has asked posed questions. When did it happen? Once you look at the affidavit of Chebukati and the timing at past 2, they are in a meeting. And by 4, they are in Serena Hotel. You will come to the inescapable conclusion that the division in IEBC was caused by the National Security and Advisory Committee. And indeed, they hijacked the 4. That is why the 4 would approach this court for the very first time in the history of this country, approach the court to seek nullification of an election that they still pretended and that they said they conducted a very good election. We ask the court to take into account that there appears to have been a mistaken impression that presidential elections are determined by commissioners. Anybody who wants to become the president of Kenya must have in his corner the Kenyan electorate. And that voter who turns up in the polling station, not the one who stays away. And if you convince that voter who turns out and you get the majority of votes, you become the president. 7 commissioners cannot make you the president. 4 commissioners cannot make you the president. Who makes the decision as to who becomes the president of the Republic of Kenya? It is our humble submission. It is not the commission. It is not any of the commissioners. It is the electorate. It is the people of Kenya. And therefore, this narrative that we are the majority, we needed to sit down and make a decision, that decision as to who becomes the president of Kenya does not lie with the commission. Theirs is to midwife the process, and that is all they can do. We wish to submit that the first respondent won these elections fair and square. You've had the submissions and the evidence that has been presented by the midwife, IEBC. And they have made it absolutely clear that this election was conducted in accordance with the Constitution. It was computed in accordance with the Constitution. And they have a very clear winner as to who obtained the highest number of votes and made all the requirements required by Article 138(4). For that reason, we ask this court to consider that this petition is the consolidated petition are founded, they are all anchored on fiction. They are all anchored in forgeries. They are anchored in fraud. That clearly tells you these petitions are built on sinking sand, and for that reason, they must fail. I wish to ask the court amply to reflect on the ruling of King Solomon. Just like King Solomon before you, you have 2 gentlemen here, each one claiming a baby. The baby they are claiming is the outcome of the 2022 election petition. During the days of Solomon, there was no DNA, and therefore he could not easily make up a decision as to whose baby is this. Today, you don't have mothers competing for this baby. You have 2 gentlemen, each one of them claiming the baby. What does the petitioner ask you to do? Just like the days of Solomon, he is telling you, give me the baby is mine. And then he goes on to tell you, if you cannot give me the baby, slice it into 2. We can call this baby Victoria. We can call this baby Victor. But the more gender-neutral term, let's call this baby Victory. Baby Victory has a clear DNA. Baby Victory, his DNA is captured in the original Forms 34A. His DNA is captured also in Forms 34B. That baby belongs to Honorable William Samoei Ruto. Give him his baby. Don't divide the baby. The petitioner here is telling you, you either give me the baby or cut the baby into 2. Nullify the election. Solomon used that indicia to know who was the true mother of this child, because no mother would want her baby chopped into two. And so by the petitioner coming to tell you here, if you don't give me the baby, slice the baby into two, you already know whose baby the victory of 2022 presidential election is. I urge the court to give the baby to the legitimate and lawful father, who is Honorable William Samoei Ruto. Thank you very much. I'm sorry, Your Ladyship, the Chief Justice, Justices of the Supreme Court, I wanted to yield the floor to my senior friend, Gatia, Senior Counsel. Thank you.
Madam Chief Justice, my duty is to make closing submissions as I also deal with the last issue. What are the appropriate reliefs? Yes. Oh. I start by apologizing. I left out two members of my team, two lawyers who have worked very hard, Rose Thiongo and Ham Langat, Mr. Ham Langat. I think in fairness, it's good I place them on record. They have done a sterling performance, and this is part of the mentorship we should do. Madam Chief Justice, let me also start by apologizing that I did not place on record the fact that we did file written submissions on 27th August this year, and we rely on those written submissions. We took lots of time to actually develop almost a treatise on the origin of Election Act. We went to 1870 in England, where we found the first codification of the Election Act, and the subsequent development and the hesitation by apex courts in not disturbing electoral victory. I would request you, in the fullness of time, please look at it. I should also, in fairness, indicate that the authority I referred to from Ghana decided last year the Mahana decision is authority number 5 in our list of authorities. And again, this, Madam Chief Justice, let me say this because I ought to acknowledge it. Judges in Ghana quoted with approval one of your judges. Writing of this apex court are now being quoted with approval in the continent of Africa. And if I could say so, this is also because of the very vibrant advocacy by my learned friends. So if we could participate in enriching the jurisprudence in Kenya and Africa, so be it. I now go to a very brief response overview. You have a petition before you by Julia, I think is now number 7, the one about special group of people, 500,000, who allegedly were denied the right to vote. And this is what we call not now fiction, but theory, pleading or drafting a petition on the basis of abstract principles. The so-called 500 people, not a single one of them have filed an affidavit to say because they were working for IEBC or were working in any hospital, they were deprived an opportunity to vote. In other words, this court must also try to establish some rules of engagement. Are we going to be holding this country at ransom as we process these petitions, which are, to say in very modest terms, very frivolous? one comes and says 500 people are denied an opportunity to vote, and then he gets away with it. Juria is a very good example of what states in America have now resolved to do. They do punish a pleader who files a pleading with the full knowledge that what is being pleaded is incorrect. I go to another area of so-called suppression of votes. This is another constant denominator, that is suppression of vote, because one level of votes was not held. And the question is, where is the empirical evidence that because there is no voting for a senator, then the turnout for votes for the presidency are suppressed, and suppressed in relation to only one candidate, not both candidates. My learned friends have talked about what yesterday was being called dysfunctional IEBC. It is not dysfunctional IEBC. It was a functional IEBC until 3 p.m. on 15th. On 15th August, towards 3 p.m., some commissioners were hijacked with their free will, and they opted to walk out from their brothers and sisters. There is a point that concerns me as a regular practitioner in this court, in these electoral cycles. And this is this. For how long are we going to allow our political class to advance self-interest, and to hold this country in perpetuity of uncertainty? That is something I think, Madam CJ, you now have an opportunity under Section 3 of your Act. The first fundamental in Section 3 is your true north, is supremacy of the Constitution. Your true north being the supremacy of the Constitution, and then other factor to consider is that this court is required to help us develop even a political path for this country. Those two becomes very important aids in how we deal with the political class. I'll come to that towards the end. But it is something of concern, because unless it is captured early, I do not see great hope in the way we are proceeding. Madam CJ, first and second respondents are very ordinary Kenyans, very ordinary, humble origin, and this is a country I always have thought is a country of hope and opportunity. Hope and opportunity for each and every Kenyan. A child from humble origin ought to aspire one day to be a Chief Justice of this country. A child of very humble origin ought to aspire to be a top surgeon in this country. I say all this because, in all fairness, unless we show hope and opportunity to all, then we'll be missing an important aspect of our growth. There were questions that were posed to my learned friends. Since I won't have another opportunity, allow me just a few minutes to deal with a few of them. I'll start with the first question about rejected votes. It was posed by one of the judges. Rejected votes is a point we litigated in Raila 1, that is 2013, not as a side issue, but it was the subject of a petition. In 2013, there was a petition dealing with nothing but rejected votes. Rejected votes, Madam CJ, can be the third candidate. It's very easy for rejected votes to be the third candidate. And in 2013 at Bomas, where I had the pleasure and privilege of being the chief agent for the candidate, it became quite obvious that rejected candidates will be the third candidate in that contest. And if they were to be factored, then the whole purpose of rejected votes is to bring down the victory of the candidate who would otherwise have won. So it is a point we litigated at length. Some of my learned friends, my seniors, we litigated at length, and this court held and found that what is to be considered are the valid votes cast. So in my submission, that is a point that has been dealt with. It was again repeated by the court in Ghana. Last year, they rejected the notion of considering rejected votes in the final tally. As a matter of fact, now that I remember, I'm getting a little older, I was clearer then in 2013, it is a misconception to call them rejected votes. It is actually rejected ballot, because a vote is that which is valid, which expresses a choice. So those so-called rejected votes are actually rejected ballot, rejected ballot papers. The same holds true for spoiled ballots, and the same holds true for stray ballots. As fate would have it, you will not even know about the stray ballots at the point that the tallying is going on. I associate myself with the submissions made by my learned friends, IEBC. They are the ones who conducted the election. It is not within our place to supplement their submissions. We wish to associate ourselves with the submissions, particularly as regards how the election was conducted. I come to what is the elephant in the room, to quote Omtata, who I have never quoted before. What is the way forward? On the one hand, you are being requested by many of my learned friends, actually all of them in unison. It's the first time I have seen so many lawyers making the same request: nullification of the election. Almost reminds me of the trial of Christ. Crucify him, nullify the election. After nullification of the election, no solution is provided. But all they request is nullify the election. As you consider the rival position, I will request you to consider the following. In the event you nullify the election, you will effectively be rejecting the substantive truth that the majority of voters in this country express their free choice. While considering that plea of nullify the election, we shall be acceding to a very dangerous trend in this country, that presidential elections are to be held, and if I'm aggrieved, not because of any error, but I want to hold the country at ransom, I will walk to the Supreme Court and the election will be nullified. while considering that request, please also consider the far-reaching consequences that we all participated, we all experienced in 2017. That is on the one hand. On the other hand, the first and second respondent come to you with a request. The request is, voters did exercise their right. Hold them to that covenant. The covenant is they made a choice. Do allow the country to now move forward. We cannot and cannot afford election mode in perpetuity. I think I have said enough to demonstrate where my mind is. It is time for finality and stability. Finality and stability. In doing so, Madam Chief Justice, you'll be sending yet another signal to the political class. And here I am not finger-pointing anybody. As I said in 2013, what I say for this client is what I'll say for the next client who is in that class. The country does not belong to them. This country belongs to all of us. And since the country belongs to all of us, no person should consider that there is an entitlement. Considering that there is an entitlement is to engage in an illusion. That illusion ought to be replaced by reality. Reality is that it is voters who make their choice. And once voters have made their choice, let us inculcate a culture that my brothers and sisters on this side are now used to. We walk to our court, we may think the law is on our side, we may think we are entitled to victory, but we accept the verdict of the court because much as we may think we are eloquent litigators, the final word is always with the court. With those comments, may I very humbly and respectfully request this court to let this cycle come to an end so that we can get back to our business, the business of developing our country. With those remarks, I would wish to close and to donate the 30 minutes to the court because we are patriotic enough to know that it's not really in the interest of this country to engage this never-ending circle of litigation. Thank you very much. Unless you have any questions for us, that's the end of our case.
Thank you very much. We appreciate the donation and the appreciation that this time that we have is very, very tight because for us, the work actually begins when we finish all this. The bench will have questions to those submissions that have been made today, but I think there are a few who might also want to add some questions to the petitioners. Especially the commissioners who are supporting the petition. I think what we want to do now is take a short health break, resume at 5:20, and this is going to be the order of business. We will ask questions to the petitioners and the commissioners who are supporting the petition. They will still respond tomorrow when they are doing their responses. But for the respondents, the first and the other respondents, we will request them to answer today the questions. We will also share the report on the scrutiny and the orders that were issued by this court on the discovery issues, the application by the petitioners. I think it was the first petitioner, Kerif Karifa, and the youth advocacy. They had applications for scrutiny. That report is being finalized. It will be shared. And tomorrow we will give you an opportunity to respond to the report. So we will adjourn for just 20 minutes.